Hello, my name is Jason Marks. I'm a tax and trust and estates attorney at Mandelbaum Barrett in Roseland, New Jersey. As part of my practice, I specialize in business succession planning, particularly for restaurant owners and entrepreneurs in the hospitality industry. This morning, I would like to talk to you about really one of the most vital but sometimes overlooked aspects of restaurant ownership, and that's planning for succession. A restaurant represents more than just a source of income for the restaurateur and embodies years of hard work, relationships, and unique identity as an entrepreneur or family member. When the inevitability comes to pass that business on, whether due to retirement, unexpected illness, incapacity, or death, it's essential that the transition be thoughtful, legally sound, and smooth so that the restaurant's legacy can continue without disruption. Many restaurant owners postpone succession planning thinking that it's something to do later. I know that restaurateurs are busy with their day-to-day lives managing and operating their restaurants, but later comes much quicker than anticipated. Delays can be costly and stressful. The absence of a plan often results in operational standstills, management quarrels among family members and heirs, cash flow crises, and sometimes closure of the business. I've seen families torn apart because of personal disagreements caused by the ambiguity and unclear direction that arises when a succession plan is not put into place. Even when there are good intentions, the lack of legal clarity can escalate minor disruptions into litigation, and that could be devastating for a restaurant's continued operations. The bottom line, prepare properly for succession. This isn't just prudent, it's essential for preserving both the business and family harmony. Understanding your business's legal entity is the foundation of effective succession planning. Many restaurants are sole proprietorships, sometimes because they were easier and less costly to start. That's not always the case now. With respect to those entities, those sole proprietorships have the drawback of tying business assets directly to the business owner, to the individual. If the owner dies or becomes incapacitated, the business technically ceases to exist until transferred through probate, which is a process that can take months to accomplish. Transitioning the business to an LLC, to a corporation, a partnership, can protect the business's continuity. These entities allow ownership interest to be transferred under agreements, operating agreements for limited liability companies, partnership agreements, shareholder agreements for corporations. These documents address what happens when the owners suddenly die, become incapacitated and disabled, or decide that it's time for them to retire. One of the things that I do frequently in representing my business owner clients is to recommend and make sure that they have a well thought out succession arrangement contained in those governing documents, the LLC agreements and the partnership agreements. These documents should specify who has the right to purchase the ownership in the event of a departure of a business owner, the method of valuation used for determining the owner's interest, when there will be a mandatory buyout upon death, disability, or retirement, restrictions on transfer of ownership interest to third parties, outsiders, if that's something that's desired among the owners, and also some type of mechanism, some type of way of resolving disputes among the members. It's important that these documents do contain these terms. These are essential. Linking buy-sell agreements with life insurance policies as a mechanism to fund the buyout arrangement is also important. But it's important also to take into consideration the tax ramifications for using life insurance and how the policies are owned and who owns them. Succession planning is more than internal corporate documents. Fundamentally, it's an estate planning exercise. I stress with all of my clients that they have proper wills, trusts, powers of attorney, surrogate decision-making documents in place so that there is a set of documents that will govern what happens when circumstances present themselves. A well-designed will, it's not just about dividing personal assets, it directs who will inherit, how they will inherit the assets, including ownership interests in restaurants. In more complex cases, the use of trusts, either revocable trusts or irrevocable trusts, is an important tool for business owners to begin to transition ownership without necessarily giving up control of the business operations. Durable powers of attorney. These are surrogate decision-making documents where an individual, usually referred to as the principal, gives authority to an agent, or also called an attorney in fact, to make financial and legal decisions on their behalf. But as business owners, those durable powers of attorney don't always extend to the operation of the business. So oftentimes it's important to have special powers of attorney in place that a business owner has, that where certain authority within the business is given to other individuals to handle certain financial arrangements in the event that the business owner is unable to take care of matters for themselves. Um, Putting the legal mechanisms aside, succession succeeds or fails because of the readiness of the successor. And I urge owners to plan as a gradual process. This is not an event. This is something that business owners, whether it's a restaurant owner or any other business entrepreneur, the idea of business succession planning doesn't happen all at once. It's something that needs to take place over time. You know, I advise owners to involve their children, their spouses, other important key people in the business operations. Everybody should know what's going on so that there are no surprises in the event that something happens with the owner. It's important to understand also that succession planning involves tax consideration, estate tax, gift tax, income taxes. These can erode the value of a business enterprise if it's not carefully managed. One of the things that I do is I work very closely with businesses, the business owners' accountants, to secure formal valuations of the restaurant, including intangible assets such as brand name, goodwill, and oftentimes also liquor licenses that are held by and owned by the business. Valuations underpin buy-sell agreements. They support gifting and installment sale arrangements, and they are necessary for tax reporting. Sophisticated estate plans might use various techniques such as GRATs, which is a grant to retain annuity trust, or a sale of ownership interest to a grantor trust, or the use of valuation discount strategies in order to start transitioning wealth and bringing in other individuals in the family to take on more of a ownership position in the business, but again, making sure that that the business owner does maintain their control for as long as they wish to do so. Liquor license. This is a complex asset owned by the business that really needs to be addressed. Unlike most other business assets, liquor licenses are generally regulated by the states in which the restaurant operates. They're a privilege rather than a property held outright, and almost always require state approval to transfer those licenses to the next generation, to the successor of the business. Many states, their liquor licenses cannot simply be transferred upon an owner's death or sale. Instead, it requires the successor to apply for the license and be approved by the state to assume that license. The licensing authorities evaluate the successor and the successor's ability based on criminal history, financial stability, residency or local presence, good character. These are the things that states will look at. Sometimes community input hearings or municipal boards are required to approve the sale or transfer of a liquor license. For sole proprietors, the license usually terminates at death, leaving the estate's executor or administrator, the fiduciary, to apply for a temporary permit or license to operate during the probate process and during the administration of the estate as the ownership of the restaurant is transitioned. Without proper application, the restaurant risks losing its ability to sell alcohol and serve alcoholic drinks, which can sharply reduce the restaurant's revenues on a going basis. LLCs and corporations often face additional steps, reporting ownership or management changes to the liquor board, and possibly restructuring both management and equity to comply with the licensing rules. Some states prohibit trusts from holding liquor license entirely or require special rules for nonprofit entities. It's for these reasons that I emphasize beginning the transfer process as early as possible. Again, this is not an event. This is something that takes place gradually, so that the owner and the successors who are going to take over the business at some point understand what are the steps that need to be taken when there is a triggering event, when the owner dies or decides that he or she wants to retire or suddenly becomes ill and cannot continue to operate the business. For those dealing with death in the middle of succession, working swiftly with legal counsel to file the necessary paperwork with the liquor authorities is critical to avoid interrupting liquor license operations. Failure to comply can lead to suspension, fines, or even permanent revocation of the license. This is something that restaurant owners obviously don't want to happen. Again, this is the reason why it's important for the restaurateur to take early steps to begin the transition process. Some pitfalls that I've experienced working with my clients include the following: relying on verbal or handshake agreements. Oftentimes, restaurant owners, business owners in general, but particularly restaurant owners who are tied up with the day-to-day operations of their business, feel and believe that having a handshake agreement among owners is sufficient. Unfortunately, it doesn't rise to the legal challenges that are often faced when one of the restaurant owners simply cannot continue to be in the business any longer. Having the legal documents in place rather than just a handshake agreement as to, how are the other owners going to purchase or acquire the interests of the departing owner? What value will be applied to the departing owner's interest in the restaurant? These are critical questions that need to be answered early and addressed in writing in a legal document. Another one of the pitfalls that I see frequently with restaurant owners is ignoring the complexity of liquor license transfer. I said before, this involves state licensing authorities, sometimes community boards to get involved, and it's very important that these complexities be addressed early on and that the arrangement to transfer the liquor license be set in place, and that the successors to the business understand what is necessary to take over the liquor license when the owner of the restaurant departs. Understanding tax and valuation complexities. This is all critical issues that need to be addressed as part of the transitioning, as part of the succession process. Having conversations with key employees, other family members, is a very critical component of the business succession plan. Delaying those conversations so that the key employees are not made aware of what's to happen when the business owner dies or is no longer able to continue on in the business. Communicating with family members, heirs, beneficiaries of the restaurant owner's estate, so that they understand who's going to take over management and the reasons why is important. It's important that as part of the business succession plan, the restaurant owner be open, honest, inclusive in their discussions with their employees, with their managers, with their family members who are going to take over. What can be done now? Review your business form and update any operating agreements, shareholder agreements, partnership agreements, whichever arrangement, whichever document is applicable to the business structure that you have. Establish, or if you've already established, revisit your estate planning documents. Look at your wills, trusts, powers of attorney. Do you have the necessary arrangements in place for the succession of your business? Choose who your successor is going to be. The person you may decide is the successor today may not be the person who in 5 years is on your list to succeed the business, or that person may not want to succeed the business in the future. Revisit these issues periodically. Don't wait for the event to happen when it becomes too late to make any changes. Begin the process of valuing your business. Understand what it is that you have. What is the value of the business? What are the values of the intangible assets, the goodwill that your business has developed over the years? And put together a trusted advisory team, which includes your attorney, your accountant, any business consultants that you may have, financial advisors, to work together to help you to transition your business so that all of your advisors are on the same page all the time. Thank you very much.